Hi everyone and good afternoon. We've just ticked over to the afternoon here in Queensland. Um, a warm welcome to all of you. There's many familiar names I can see on the screen and some new people. So if you're new to the Quality Collaboration Network, welcome. This is a network for community organisations in Queensland and for those who have a role where quality and compliance is part of the scope of your role. We meet together monthly online and explore all things quality and compliance. And a lot of us are complying with the Human Services Quality Framework, and that's really the common thread that pulls us all together. My name is Stacey DeCalmer. I'm the Executive Director for Sector Workforce Planning and Development at QCOS, the Queensland Council of Social Service, the peak body for community services. The team and I have been running the QCN for many, many years now. So thank you for joining us. I am working from home today, so I'm actually on the lands of the Yugambeh speaking nation, and I'd like to pay my respects to their elders past and present and extend that acknowledgement to all of the traditional custodians across Queensland where we do our work. And for us in the QCOS office, that's often the Yarra and Turrbal people, so I'd like to pay my respects to them and any First Nations people who are joining us on the line. I know that incoming legislation is something that many of you have been thinking about across this year. There have been a few changes for organisations in the last couple of months. IPOLA is just one of them, and of course we've had the Child Safe Organisations Act as well. So I think many of you have been busy reviewing policy, incorporating legislation into policy, and of course thinking about what it actually means for your practice as an organisation. We are really fortunate to be joined today by Joanna Green, Principal from Hive Legal, who has herself and her team done some amazing background work for us to really help us understand what our obligations are as service providers under the Information Privacy Act. So I am going to hand over to Joanna and thank her in advance for the great information I know she's prepared for us.
Great. Thank you so much, Stacey. Hi, everyone. We're very pleased to be here and to be helping out this amazing organisation, all the very important service providers for Queensland, doing very important work. So thank you. I've also got Minna, who's a senior associate in my team, and would like to thank her and Laura, who have also been assisting to prepare not only this presentation we get to come and talk to you about, but also hopefully an information guide too that you can refer back to in future. We'll be circulating later. So perhaps a little bit about us. So we're commercial lawyers and advisory lawyers. So we help organisations and government agencies as well to understand what their requirements are in relation to the law, and particularly when it changes or you have a new project on. Particularly in like health and government sector as well, so in family services. We are based down in Melbourne, so I'm presenting from the land of the Wurundjeri people today, and yes, we are into our afternoon already. But no, very much, very grateful to be here, so thank you. Just to let you know, as usual, I think this session has been recorded for those that couldn't make it today as well, so keep that in mind. We are very happy to answer questions along the way. If you want to submit them, Stacey can keep an eye on them. We'll pause and make sure we've got time for them as we go. Please jump in if there's anything that doesn't make sense, or I've skipped over, or I've used acronyms that don't make any sense, because it's, yeah, the hour really is for you and to help everyone feel a bit better in an hour's time, hopefully, about what the requirements are and how you can go about complying with them. So in addition to Stacey's acknowledgement, we acknowledge the traditional custodians of the land on which we work and live, and recognise their continuing connection to land, water, sky and community, and we pay our respect to elders past, present and future. So on this slide, we've got our agenda for today. It is ambitious, we acknowledge, but there's a lot to get through, particularly focused on what is expected of community service providers regarding privacy compliance under the IPA, that's the Information Privacy Act. Short, we're going to call it the IPA, I think, throughout, and save some time. We'll be focusing on whether and how the IPA applies to community service providers working with Queensland government agencies, which we understand a lot of you are. We will point out any changes to these expectations following the recent amendments to the IPA, because there were previously already obligations, but they have changed recently, so good to be aware of that. We'll also be talking about the IPA obligations to which you might be bound by virtue of a service agreement, and we've seen and reviewed the template service agreement that you're probably required to sign and acknowledge when you get funding, particularly from the state government. But there may be different versions of that as well. We will provide an overview of the newly introduced Queensland privacy principles. That's quite a material change, probably similar in theme to previous privacy principles, but a modernisation of how and what is expected when you're handling personal information for Queensland government agencies. And finally, we will be talking about the data breaches, the new data breach regime and the mandatory notification scheme that has been introduced as well, and what are your requirements as a community service provider in relation to that. We will wrap up, hopefully that won't allow me too much, we will wrap up with some key takeaways and tips and some practical suggestions that you can take away with you, but welcome questions along the way. Because we are lawyers, we throw in a disclaimer as well. So just to know that what we're covering in this session is general information only. We don't have individual instructions from any of you about your individual circumstances, so please take it in that light. If there's anything specific for advice that you need, please reach out by QCOS and Justice Connect, and there's lots of other free services as well. I appreciate the budget is probably not overflowing for anyone. Perhaps just a moment of reflection, looking at this slide, and we will come back to it at the end of the session too. So if you're asked to explain your organisation's privacy obligations under the IPA and the procedures for handling a privacy breach, which icon might best describe you, you can have a look at any of those options. It's quite a variety there. A couple are happy, a couple seem a bit relaxed. Some are enthused. I think maybe Minna's kind of very enthused. She might be the love heart. There's not many. We appreciate privacy lawyers are, a special breed amongst ourselves. So, have some thoughts on that, and then hopefully we're feeling a bit better, moving towards kind of the right-hand side by the end of the session. Okay, so the Information Privacy Act. So you'll note that's the original still says 2009, but that act includes the IPOLA, and I understand everyone's been using that acronym with the recent amendments. So the recent amendments have been kind of subsumed in the IPA. So we're talking about both of them. So we'll start by looking at the relevant provisions of the Information Privacy Act and pointing out recent changes to the IPA that are relevant to community service providers, and also suggest tips to assist with any new compliance expectations. Really important, I think, people are probably very interested in wanting to hear about the very sexy, new, scary data breach regime, but I think it is important to kind of start at the start. And that's why we wanted to go over some really important basic concepts. So apologies if you are fully aware of all of these, but it doesn't hurt to go back and step through these, because you kind of don't know what your actual requirements are in relation to the data breach regime unless you know kind of what type of agency you are, what type of information you're doing, what kind of services that you're doing with an agency. So they're really important factors to consider. So the IPA, as a kind of scene-setting exercise, it regulates the collection, the use and the disclosure of personal information in Queensland public sector agencies. So you might be aware, probably there's a Commonwealth Act for privacy as well, and there are state-based acts as well, and they're largely very similar. It's just who they're really focused on governing and regulating that is probably the main difference between them. So the state-based acts are focused on state government agencies because they're typically not covered by the Commonwealth Act. So maybe if you had a question over here, how they might both align, and there's some interaction between them and there's a lot of similarities, but they're the key focuses of it. So importantly, if you're a private, not-for-profit community service provider, you're not the main aim or the main focus for this piece of legislation. You may be bound up by having an arrangement of providing services to or on behalf of a Queensland government agency. So that's the first thing kind of to keep in mind. So the Act includes 13 Queensland privacy principles now in Schedule 5, which guide how personal information may be collected, used or disclosed, in particular by the agencies. We often think of a life cycle of handling of personal information. So it starts when, before you even collect information, you kind of have a privacy policy and you tell people about how you're going to handle information. There's principles about how you collect information, use it, disclose it, store it, give access to it, and then probably get rid of it. So it is a real kind of life cycle of all the different risks that you may have when you're handling personal information. And we'll go into them a bit more in the session. But now the IPA also includes a new mandatory notification of data breaches scheme applying to Queensland agencies, which is now in Chapter 3A, capital A of the Act. A big congratulations to Queensland, because I believe this is the first state that's really legislated in this space. So we've had a Commonwealth regime for private organisations for a couple of years now. Might even be a bit longer than that. And so we're still getting kind of used to it in the private sector, but there'd been quite a different requirement in relation to the state agencies. And so I know Victoria's watching very closely in relation to Queensland leading the way in this space, but the sensitive nature of the information that government agencies hold about us, there's a real expectation growing that why wouldn't they be treated and held to a similar standard? That's probably a good reminder of how privacy law even came around, because there's a realization that we actually don't own the information about us. The organizations or people can, make information about us, but over kind of the last, few decades, it's really seen as a human right. It's growing out of a human right that we would have rights to understand how our information is being collected, being used, that if it's being disclosed, etc., and being notified of various things, access information about us. So that may even surprise people when you think, oh, but it's about me, I should own it, I should be able to control it. That's not necessarily the case. We're starting off a basis of actually we don't own the data about ourselves. So you as an organisation, if you control the data, you may own the data as such or create data. It's just you may have obligations and rights in relation to the individuals about the data. So a really key aspect of this, not to skip over, is privacy law is in relation to personal information. And this is broadly similar across most privacy acts. So if we were talking about data that had nothing to do with people, maybe it was statistics about pens and paper that didn't relate to people, an example. But if it's not in relation to people, it's probably not personal information. And so if there's, jumping right to the end of the session, if there was a data breach in relation to information that's not personal information, maybe finance information of the organisation, someone's lost a credit card or something like that, we've got to be thinking, is it personal information that we're dealing with? So what's personal information? So we've got a bit of a checklist on the slide. So it's defined in the Act as information or an opinion about an individual who's reasonably identifiable from the information or opinion, whether true or not, and whether recorded in material form or not. So that's very lawyeristic, very detailed definition. But to break it up, so we're talking about information that may be information, maybe an opinion about someone, so it doesn't have to actually be accurate, maybe true or not. Whether it's actually recorded somewhere or saved somewhere or written down, it can still be personal information that I might disclose verbally to someone. But it must be about a person, and that can get into a really interesting legal discussion about whether something is about a person. There's been some interesting cases about metadata, so device location, for example, or device identifiers, lots of things can potentially be information related to a person. It might not be about a person. So if you're unsure, seek advice. Might be better to err on the side of caution and assume everything is personal information, but if you're in a tricky situation where you're not sure what to do, I'd say worth seeking legal advice. And the person's identity is either readily apparent in the information or can reasonably be identified from the information opinion. So what we're trying to say there is it's not just in relation to, we've got a list on the next kind of slide, it's not just in relation to someone's name and phone number. That's what we might clearly know is personal information, but it also includes maybe a Centrelink number about someone if you happen to be able to search and re-identify someone, or date of birth or age or postcode if someone has quite unique circumstances that you could identify and information about them. So here's a bit of a list. Some of them are quite obvious, but some of them perhaps less so. A signature, a fingerprint, financial details, photos or video footage of a person, their CV or resume, etc., etc. So lots of different things, not just the most obvious items could be personal information depending on how they're used. Worth making a note at the moment here for if information, and you might often do this for reporting purposes. If you've gone to the effort of de-identifying information, or only kind of collecting aggregate information, and you can no longer identify someone in relation to that or re-identify someone, that might not be personal information. But as technology has evolved and data sharing has evolved, it's actually really tricky to get to a state where information is fully de-identified. And so we just recommend exercising caution if you are not assuming that the privacy obligations don't apply because you've de-identified information. And there was a very interesting case in relation to public transport data in Victoria that was given to researchers in an open kind of environment, well-intentioned. Let's understand some trends and some policy around that. Everyone assumed the data was de-identified, but it was re-identifiable by connecting it with other data that was out in the public domain. In particular, they were able to re-identify a minister's MyKey number. So we have a public transport card called a MyKey. And then by connecting those two dots, you could actually see everywhere that the minister had been, for example. And everyone had been doing everything really well-intentioned, and the researchers disclosed that immediately and kind of shut it down. But it's just a really good reminder of, even in a data set, when you're just looking at that itself, you've got to think about what it can be re-identified with, and that may change in future too, and who you're sharing it with. So into the juicy bit. So I understand what personal information is. We're reminded of what that is now. But I was touching on before what I mentioned, that the actual act itself, and there's lots of different parts of the Information Privacy Act, but they're really focused on agencies because that's the permission that the state has to legislate and regulate over. So there's a few elements of the definition of agencies that encourage people to go and look at to make sure, because we'd assume that most of the community service providers that we're talking to are not actually agencies or not intended to be caught as agencies themselves, and it's important. We'll explain why it's important again. The obligations of agencies are much broader than just community service providers for limited purposes. So if you're an agency, you've got to look at the whole act. And you definitely have to look at the data breach scheme. It applies to you directly. So agencies are typically the obvious ones, the departments and ministers, authorities created under statute, but there are a bit broader kind of nuanced definitions. And in fact, there's an ability to declare in regulations, of which it hasn't been done just yet, essentially that a private organisation could be declared an agency under regulations. I think we would assume that people would, your organisation would know if that was going to happen to you and or had happened. But we're imagining that would probably be exercised in a situation where an agency is a community service provider is providing very highly sensitive and important and valuable services to an agency that's very public. And I would say there was kind of similar discussions around when Telstra Health took over and provides the Commonwealth government as a funded service provider a number of very highly sensitive health programs, the National Cancer Screening Register and the Bowel Screening Register, for example. And so I think the community expect a very high level of compliance by a private organisation that has such a public operation. So the takeaway from that is understand if you're an agency, you probably won't be, but perhaps don't just assume that you're not, and have a look. So there's a definition in Section 18 of the Information Privacy Act about agencies. So double check through the list, or if you just happen to be created under an act, or a governor and council was created your organisation. It's just that we don't know everyone's individual circumstances. So just lost the slides. Have you got lost them?
Oh,
maybe that
sorry,
didn't work.
Jo, my cursor could just take control on top. Is there a take control thing?
Choose everyone. I'll try and share again. I wonder if the live thing affected it, but should be nice.
there we go. We're back again.
Back.
There we go. Apologies. So yes, confirm if you are an agency, because agencies have obligations under the Information Privacy Act. Could cover it on there. So what if your organisation is not an agency? So maybe for most, if not all, everyone on the call and watching later, what if you're not an agency? So that's perhaps some good news in relation to the Information Privacy Act and what you're required to do. But there is another way for you to be essentially swept up to made to comply with some of the provisions of the Information Privacy Act. Not all of them, but some of them. So this will apply if you are what's called a bound contracted service provider. It's a bit of a mouthful, bound contracted service provider under the Act. Essentially, the way you do that is by signing or agreeing a service arrangement with a Queensland government agency. And thinking back to what the agencies are, they're basically every state agency you'll be aware of, departments, ministers, state entities created under legislation, etc., or by governor and council. So that service arrangement, that doesn't have to be in a particular form. But if you have signed the template service agreement that is public and is very commonly used, that will likely satisfy the requirements of being a service arrangement. We can tell that because in clause 18.1, it says in A, it says comply. If you collect or have access to personal information for the purposes of this agreement, you must comply with parts 1 and 2 of chapter 2 and section 41 of the Information Privacy Act in relation to the discharge of your obligations under this service agreement as if you were us. And that's really the crux of it. So if you've signed that service agreement, you are likely to be a contracted service provider. I would say that would be the safest assumption to go. There are slight nuances about that and exceptions, particularly around the nature of the services that are being provided and how personal information is involved in those services. So if you were providing services just back to the agency, for example, and it had nothing to do with personal information, it's perhaps hard to try and think of that in this scenario, but maybe some project design work or something, some funding program work, collaborative design work, statistical analysis that really didn't have anything to do with personal information. There may be exceptions that you may not be bound in this way. But I'd say those exceptions are fairly limited, so be careful if you're looking to enliven those. So yes, you'll be a bound service contracted service provider if you provide services for the performance of the agency's functions, and that's another important one. Like, is what you're doing is the service arrangement in relation to the agency's functions, which you can perhaps, if you're lucky, that might be set out in legislation. That may not be so obvious. Or if you provide service to the agency or to another third party on the agency's behalf, and that's, you know, we often see that of if you're providing a grant scheme, for example, or you're providing, you know, service in the disability or the family violence or any of the common sectors I'd say you're involved in. If you're providing services on behalf of the agency, likely to be involved. And many of the services, I expect most, probably handle personal information too. As long as you're not providing the services in the capacity of an employee of an agency. So that's a slight exception, but again, probably not overly relevant. So, for example, an organisation which provides community support for independent living under a funding agreement with the Department of Housing is likely to be in a service arrangement with that department. So, yeah, just to highlight an example, but there's probably many, and there's probably some nuances, we would say, as that.
Yeah, you've been really sharing.
Okay, so time is going very fast. We're up to 12, right? So community service providers, privacy obligations under the IPA. Okay, so if we've established whether or not you're an agency, we've established whether or not you are a bound contracted service provider because you have a service arrangement in relation to those situations. If you're a bound contracted service provider, you will have obligations under the IPA, but they are limited. They're limited to what's likely to be set out in your service arrangement, but it's also set out in the Act as well. And in those circumstances, for those limited purposes, you'll be treated as an agency under the Act. So the Act doesn't say in these relevant provisions, both an agency and a bound contracted service provider has to comply with QPP1. It just might say an agency has to comply with QPP1. So, but we need to kind of read that into it ourselves. So the IPA refers to a service provider bound to comply with the certain IPA obligations under the service arrangement as a bound contracted service provider, which is a mouthful. So we've mentioned, yeah, an organisation that is a bound contracted service provider for the purposes of the IPA will be bound to comply with certain obligations, but only where the service arrangement typically involves personal information. So thinking back to, are we handling personal information? So the IPA requires that in the service arrangement, a community service provider will in any way deal with personal information of the agency, or the provision of service under the service arrangement involves transfer of personal information to the contracting agency or the provision of service to a third party on behalf of the agency. They're trying to capture all those different scenarios that might apply. Then we need to look at what does the IPA say. So important to identify what information we're collecting or using or sharing under the service arrangement. And if this involves personal information, have a close look at the terms of the contract. So I will now hand over to Minna to talk about the IPA obligations.
Okay. Thank you, Jo. So which IPA obligations apply? So Jo has already foreshadowed this and spoken about the obligations that are referred to in the service agreement contract. And they're also specified in the Act, Section 36, which says what the agency has to bind the service provider to comply with. So the service provider under Section 36 is required to comply with Part 1 of Chapter 2, which is compliance with the QPPs. Part 2 of Chapter 2, which has to do with the conditions under which you can disclose personal information outside of Australia, and Section 41, which requires agencies to comply with any QPP codes that apply to that agency. So those things, as they apply to agencies under Section 36, have to be complied with by a contracted service provider, bound contract service provider, as if they were the agency, and the regulator can enforce compliance in the same way. And some of these are similar to the kind of obligations that would have been in a contract previously prior to the amendments, and some of them are new, so we'll point those out. So an important point to remember is that the obligations under Section 36 regarding personal information continue even after the service arrangement with the agency has ended. So that's a really important point, is even if you are no longer providing service to the agency, if you have personal information in your control that was obtained through that service arrangement, you are still bound to comply with these laws. So we'll now look at the different obligations. We'll just try to do that quite succinctly. So the compliance with section with the QPPs, a contracted bound contracted service provider is required under Section 27 to comply with the Queensland privacy principles. And these were actually, as Joanna mentioned, they were introduced with the new amendments. And previously, the IPA included 2 sets of privacy principles, which very briefly, there was health privacy principles, which applied to the health agencies, and then there were the national privacy principles, precursor of the Commonwealth APPs, which apply to all other entities. And as part of the amendments, the aim was to streamline those and to have one set of principles. So the QPPs are not radically different from what previously applied, but oh, sorry, that went forward, but they are now streamlined. So these QPPs apply to a bound contracted service provider. And as we said, again, to remember that these will continue after the arrangement has ended. And the next one that's listed in Section 36, which has to do with disclosures outside of Australia. So again, that did apply previously. Section 33 sets out a list of conditions under which an agency can disclose personal information outside of Australia, which now under Section 36 will apply to a bound contracted service provider. And these include permitted disclosures with the person's consent, but there are also some specified circumstances where you may be permitted to disclose personal information outside of Australia without consent. For example, if required by law, or if there is a question of a person's health or safety at stake. So these conditions under Section 33 will apply for a bound contracted service provider in the same way as they apply to an agency. And the service provider will be liable if it does disclose personal information overseas without authorization under that section. So if you are considering disclosing any personal information collected or handled under a service arrangement, it's probably advisable to seek some specific legal advice about that information and where you want to disclose it and for what purposes. And the last one is compliance with QPP codes. So this is a new introduction of the amendments and came into effect in July 2025. So you would not have been dealing with this previously. So Chapter 3 of the new Chapter 3 of the Act now has a system of arrangements for making and getting approval for privacy principle codes, which are codes which set out how a particular QPP or a set of QPPs apply specifically to a particular agency or group of agencies. They can include obligations beyond what's stated in the QPPs. And a bound contracted service provider is required to comply with any QPP code which applies to the agency with which it contracted. So that was also, again, a kind of convoluted sentence, but the idea is that if you've contracted to provide service to a particular agency that is bound under particular codes, so if we just said there was a code that applied to all Queensland public sector agencies, and you were contracting to provide service to those agencies, you would be likewise bound by that code under this section. It's quite a new amendment, so it's early to have any QPP codes in case, but it's something to bear in mind. It may become relevant to contracted service providers in the future. So this slide is just to illustrate the changes that we were just speaking about. And again, they're not radically driven, but with a few new introductions. So you'll see the previous section 36 on the left-hand column of the slide, and the amended one on the right hand. And so the references part 1 and 2, that has to do with just the fact that because we now have one set of privacy principles, so part 2 and part 1 became one, and then part 3 became part 2, etc. So that's really compliance with the principles. Part 3 had to do with the disclosures outside of Australia, which is now part 2, but section 41 is completely new because of the new arrangements for QPP codes. So that's quite new. What is important for contracted service providers to know is that if you were in a service arrangement with an agency immediately before these amendments took effect, you are actually bound under the previous sections. So you would have to comply with the IPPs and MPPs, et cetera, as they were prior to the amendments. But you can discuss with your agency. It's possible to vary the contract and to bring it up to date with the new amendments, and that could simplify things. So that's something that, if you are in that position, you may want to consider together with the contracting agency. So we thought we'd just stop here for a moment because it's a lot of information and there's a lot of detail in this presentation. Thought we'd stop and see if there were any questions before I throw it back to Jo. Have any questions come up?
We've got nothing in the chat, and everyone, your cameras and microphones should be working now if anyone does have a question. Can't see any hands up, and there isn't anything in the chat, so I think we're good to keep going. Thank you.
Okay, back to Jo then.
Thanks, Mina. Great. Okay, so conscious of time, and this probably could be a whole session on itself. Maybe we'll, if you would like us to do a whole session actually on the QPPs before we invite ourselves back, if everyone's actually interested to hear more. Maybe we could, so we'll go light on the QPPs for this session, but yeah, the absolute offer to come back and do it in more detail. Touched on before, yeah, think about it as a life cycle of handling personal information. But broadly, there's probably nothing really strikingly different about the QPPs and what your previous privacy principles or what you may be required to comply with in the Commonwealth Act. So now there are a single set of privacy principles applying for Queensland agencies. Hopefully that's an improvement. They address, yeah, thinking about the collection, the use, the disclosure of personal information throughout the life cycle. They're often phrased, in Australia sees a bit of criticism about it, to be they're principles. They're not often black and white requirements. So they often have words like take reasonable steps to, what are reasonable measures in the circumstance. And so that gives a little bit of wiggle room, but also makes it a little bit vague and uncertain. There's a very interesting case, if you're into this kind of space, under the Commonwealth Act recently, that did a bit of an assessment of what reasonable steps were, and it really looked at lots of relevant circumstances, but how sophisticated the agency and how much resources the agency, the organisation had to take steps. And so in light of your organisations, that would be considered a really relevant factor, but not necessarily a get out of jail free card. And we'll talk about some cheap and easy ways to hopefully reduce risk going forward. So we have mentioned, don't forget about the Privacy Act, the Commonwealth Privacy Act. It may apply to you. You may have an exception at the moment about being a not-for-profit. That may be reviewed in future, so keep an eye on that. And in particular, if you're dealing with state-based data, there may be specific provisions in both of those acts that govern how you deal with that and might actually bring it back under the State Act, not the Commonwealth Act. So again, that is a a tricky area, but worth noting. So here's a slide, and happy to share the slides, with you by circulation. But really, they start at the start of the life cycle, open and transparent management for QPP1. Particularly, that's usually a requirement to have a privacy policy and tell people about how you're going to handle information. QPP2, allowing people to be anonymous if it's reasonable. Very often it's not. Or use a pseudonym. So just be mindful. For example, if you're asking for a survey, do you really need people's actual identifiable information? The best idea is to not collect any more than you need to, because if you don't have it, you can't lose it. QPP3, so then we get into the collection stage of life for data handling. QPP3, collection of personal information when it's solicited, when you've asked for it, or dealing with unsolicited personal information. You've got a wrong email, you've got information that you did not request necessarily, how to deal with that, and notification of collection. QPP5 is the reason, and its equivalent is the reason why people should be telling you at the bottom of a form how they're going to handle information, and there's usually some things that need to be covered off in that. So then you've collected the information, and now what are you going to do with it? There's a QPP about use and disclosure, and often it might say, it's kind of obvious that we can do things with consent, but there are exceptions or where you don't have consent as well that will be listed in there. Thinking about direct marketing, probably not a big concern for your organisations. Cross-border disclosure about, particularly when you're even transferring information outside of Queensland, which can include kind of overseas data server hosting servers or providers overseas. QPP9 is perhaps not the most famous one, but probably really relevant for your organisations, about adoption, use and disclosure of identifiers. The QPPs do not provide an equivalent for APP9. So it's particularly focused, and Minnie, you can jump in if you've looked at it a bit closer about. So under the Commonwealth regime, you'd be careful not to adopt another government, so private organisations, not to adopt a government related identifier. So your Medibank, your Medicare number, your Centrelink number, etc. You should be creating certain records for your own sake and not kind of adopting other people's identifiers. Integrity of personal information. So trying to make sure that there's a quality of personal information, that it's secure, that you give access to the relevant people and correct it if needed. So that's a very brief overview of QPPs. And we might skip over these examples. I think we've given some already about when they might apply. And I might throw back to you, Mina, for some data breaches, which I know everyone's very excited about. 15 minutes left.
This is what everybody finds so juicy. But I mean, the truth is, and okay, to start with the introduction, the July 2025 amendments introduced Chapter 3A, which is a mandatory notification of data breaches scheme. And as Joanna said, it's very trailblazing for Queensland, and it's new. It's a significant addition, and it introduces detailed and new requirements regarding assessing, notifying, and responding to any actual or suspected data breaches. But what's really important, and which Joanna has mentioned already, is that it applies to personal information held by agencies. So in most cases, it does not apply directly to most community service providers. So that's the first step. However, just like the other things we've been discussing today, it may be, and it would be relevant to a community service provider's obligations under the service arrangement. So it's still important for community service providers to understand the scheme, even though they are not directly bound to it, because their service agreement will refer to it and require them to comply with certain aspects of it. So what is a data breach, firstly? So again, as it's defined in the IPA in Schedule 5, it is unauthorized access to or unauthorized disclosure of personal information, or the loss of information in the circumstances where unauthorized access to or unauthorized disclosure of the information is likely to occur. So I mean, there may be different definitions of data breaches as far as the mandatory notification of data breach scheme. We're going with the definitions of the Act. So what is the scheme? So the scheme, as we said, was introduced in Chapter 3A, and importantly, it only applies to eligible data breaches. So not every actual or suspected data breach needs to go through the process of the notification. And we'll go right on to a definition of eligible data breaches under the scheme. So you'll see that they are data breaches which involve unauthorized access or disclosure that is likely to result in serious harm to the person to which the information relates. Or if the personal information is lost in circumstances that there may be unauthorized access or disclosure, and that is likely to lead to serious harm. So obviously the degree of harm here is an important aspect to assess, and is the central criteria probably to criterion to whether it's an eligible data breach under the scheme. And the Act does provide a list of matters which should be taken into account, such as the sensitivity of the information, for example. So there's certain information that's considered more sensitive. Health information is more sensitive. Information about ethnicity, if somebody has a criminal record, these sorts of things are more sensitive information. And the misuse or loss of information is likely to lead to more serious harm. And if that happens, it's more likely to be an eligible data breach. So it's not just a process of thinking that there's been a data breach, but there's a process of assessing if it's an eligible data breach. So the mandatory notification of data breach scheme does not directly apply to community service providers. However, the Queensland Government Service Agreement, which we've been discussing, includes a clause that requires service providers to notify the agency if they become aware of anything that might constitute an eligible data breach under the IPA. So the agency has notification requirements towards the regulator and towards some of the individuals. The obligations of the service provider are first notification of the agency, but the reference to eligible data breaches is a reference to eligible data breach as it's defined in the Act. So it is important that a service provider knows what an eligible data breach is, so they know what their commitment under the service agreement is. So what do you need to know about the scheme? So as we emphasized, the requirements of the scheme apply to the agency, but under the service agreement, it is important that you can make sure that you are aware of and that you comply with your obligations under the contract, which currently require you to know what eligible data breach is, so that if you suspect that one has occurred, you immediately notify the agency. That is a requirement under clause 18 of the contract. So it has a requirement to notify of data breach, but it specifically says anything that would constitute an eligible data breach as defined in the IPA. So it is important to be aware of what an eligible data breach under the IPA is. And they also, the IPA requires that the service providers assist the agency in meeting its mandatory data breach notification requirements. So it's important for a service provider to understand the workings of the scheme, because a contract requires the service provider to assist and provide the correct information, etc. So this seems like an apt place to put in a few tips and steps for how to reduce the risk of a data breach or the need to report data breaches. So just to go through them relatively quickly. Firstly, data security, making sure that personal information is securely handled and stored, and that there are appropriate access limitations, which Joanna has already touched on, that access is on a need to access basis. For using only secure links to communicate personal information, to transfer documents. In offboarding, and this is something which you can slip up on, when offboarding employees or subcontractors, make sure that any access is revoked, any electronic or hard copy files are collected, any passwords, existing passwords, etc., are removed. And also, this is important, having processes in place to respond to the end of the breach. So it's highly recommended that within an organization there is a person, a member of the organization, who is responsible for dealing with suspected or actual breaches, or receiving a complaint regarding a potential data breach, and then for leading the response to any suspected data breach. And here we'll mention data breach response plan, which is highly recommended and sets out how you plan to contain the breach, how you're going to assess the breach to see if it's an eligible data breach under Act, notifying the agency. And again, for the agency, there's notification of regulators or individuals, but for the service provider, the main thing is notification of the agency. But then there's the issue of resolving the breach and identifying lessons learned and steps taken to reduce the likelihood of a breach occurring in the future. And the last point is in ensuring that all staff and volunteers are trained and understand their privacy obligations, and that any contractors and subcontractors are obligated under contract to comply with privacy obligations. So, of course, there's nothing that is foolproof, but these safeguards can really significantly reduce the likelihood of a data breach. So I think, oh no, there's one more point, sorry. This is just quickly, we have mentioned the interaction between the Commonwealth law and the state legislation. So this is relevant because some of the community service providers, as Joe has mentioned, will be bound by the Commonwealth law, as in their own right, and might be APP entities, not all of them. And under the Commonwealth law, it has its own notifiable data breach scheme. So if a data breach occurs, what does that service provider have to do? So just to clarify that within the service arrangement with the agency, and with regard to the personal information collected or handled within that arrangement, the Privacy Act exempts the service provider from the notification under the Commonwealth Act, and the service provider should follow its obligations under the contract to the Queensland government agency in this instance. So that may come up for you, that may not, but it's an important, because otherwise it could be quite confusing to decide which scheme to actually follow. So with that, I think I'll pass it back to Joe for some takeaways.
Great, thank you, Minna. Yes, so we're conscious that's been quite a bit of information so far in the session. I think some real key takeaways are there's probably been a lot of discussion about the changes recently in Queensland, but for contracted services providers, they're probably not really significantly different in relation to the privacy principles. Keep an eye out for the codes, QPP codes, if they come in. Check and confirm if you're an agency. Check your contracts to think about if you've got a service arrangement. Become more familiar with the QPPs and actually what they require. But again, there shouldn't be, some, new and scary things in there. They're probably much more similar. And be conscious of the agencies that you're working with will have this new obligation. That will be quite new for them about the mandatory data breach notification regime. It's a big mouthful. And so they wouldn't have probably been bound by the Commonwealth Act before. But it seems the regimes are very similar. That there's not only authorised access or loss of data, it also has to have a serious harm impact as well. So I think there's some key takeaways, and the practical things that you can do are about processes, as well as systems. And they don't always necessarily have to involve a significant cybersecurity expense, or it's not all about tech. People are a very important aspect. Emails just going to the wrong people is still a very highly and very common thing. So that's where the secured link might come in. So if you can share a secured link in a OneDrive that only has access to limited people, that's a very, very important practical step to reduce accidental sharing going on email. Multi-factor authentication, if you can send that up on any systems. But really some takeaways of It's like, be clear about whether your organisation is an agency or not. It's a really important one to understand. It will really significantly change your obligations. And when you're not an agency, be aware that you may still be a bound contracted service provider, and confirm if you are or have been for service arrangements. So thinking about that. Don't sign the contract and leave it in the bottom drawer. I know this is painful and not as exciting for everyone else, but have a look at your contract. It is, quite clearly drafted. If you need legal advice, go and ask for it. Ask the agency to explain it to you, if you're not quite sure as well. If you're bound under a service arrangement existing before these amendments in July, there might still have been provisions in them. So there's some elements that are not entirely new. So there is a mandatory notification data breach scheme that exists now for agencies. I think really the most important thing that we could probably tell people, if you haven't had to notify a data breach as yet, is everyone feels sick when you first realise that this has happened or may have happened. You really wish it didn't. You can kind of go two ways, and it's a really interesting human phenomenon to want to just pretend you never saw it, not tell anyone and pretend it might go away and no one might ever notice or bury it. That is, I think that's quite a psychological response. The best thing for everyone is to tell someone and start a process. Have a process so you don't have to think about it. Okay, and there's usually very clear 4 steps. Again, this could be a whole session in itself of try to contain the breach, consider who you need to notify. Oh God, I'm missing one. Contain the breach, assess it, notify, and think about how we might try and avoid it in future. Very clear, very practical, common sense steps. You need that if you're looking at a situation where you're really worried about your relationship with the agency, your reputation of them and everyone. It's just better to tell people, and the process is just, notify it and let the process go and learn from it. The more you ignore it, it doesn't get any better, I promise. What else have we got here? A couple more. You can take steps to reduce the data breach risk. They don't have to be high cost. They don't have to be very complex. Think about practical steps that you can take, including a data breach response plan. Even if it's a 1-pager, I'm sure we can get some examples and probably from the regulator. Understand what personal information you're dealing with, where it's going, where you're getting it from. Try and maybe have a map or like different systems, perhaps, if you can, or understanding of where you might be able to track the information where it's come from, and know your obligations under the service agreement and the Act. Think about what happens after the expiry of the agreement as well. Seek legal advice and look at the awesome QCOS resources and policies there that are, I believe, being updated as well too. So that brings us right at 2 o'clock. Apologies that we're right at time. We're happy to stay on if others can, but conscious of you might be running off to another meeting. But apologies if that's a lot of information. I hope it was really useful. We're happy to stay on and chat or answer questions afterwards, and we can input it into the information guide to send out.
Yes. Thank you so much, Joanna and Minna, both, for not only the amount of background work that goes into understanding the legislation, but also contextualising it for us and our different service delivery scenarios. Really appreciate that information. As Joanna has said, we've recorded the session. We will send it out, and we'll share the slides as well. And as Joanna has just mentioned, we will also have an information sheet or guide that we'll be distributing to services across Queensland. I wanted to remind you all to, Joanna just mentioned MFA or multi-factor authentication. That is just one of the ways that organisations help to protect data. And I wanted to remind you that if you have identified that you do have some IT gaps, limitations to your capability within your organisation, please don't forget that Info Exchange specialises in not-for-profit tech capability. You're able to get in contact with them for advice or for some help in managing those kinds of transitions if you're trying to implement systems in your organisation. So don't forget that they're around to help as well. I've been making notes over a few months actually of some new documents that we might need in the HSQF policies and procedures suite of resources that we have on the QCOS website. So that data breach response plan was something that I noted down. So thank you, Joanna and Minna, for mentioning that. That's something we can add to our wish list of resources for the sector.
I'm happy to help on them as well.
Thank you very much. Would really appreciate that. Is there any questions before we wrap up? I do know we're over time now, so just checking to see if there's anything. I think your information was so comprehensive that we haven't got anyone there who's put their hand up, and there's nothing in the chat, but Cindy has said that it was really useful. So thank you. Thanks, Diane. Thanks for coming. And thanks to both of you.
Appreciate it. Thank you so much for having us, Stacey. Thank you. Yeah, really appreciate it.
Thank you so much. Thank you.
Thank you very much to both of you. The contact details for Joanna and Minna are there on the screen for you, but we will also send them out in our post-event email. So thanks very much, everyone. And I hope you have a good afternoon.
Thanks everyone. Appreciate it.
Thank you, everybody.